Your panel this afternoon includes Judge Golden, Judge McGee, and Judge Armstrong, Judge McGee, and I'm Judge Golden. Is there anything we need to discuss before we begin?
No, Your Honor.
Oh, yeah.
May call the case.
Gehlen Liebetreu versus Sandra Liebetreu.
Your Honor, this is Greg Smith. The real Greg Smith is sitting across from me. I have to tell you, we've known each other remotely for an awful long time. We've met each other on occasion, but I have a stamp in my office that says, a stamp mail that is addressed to him, to the real Gregory D. Smith. And he's always been a pleasure to work with. I want you to know, I talk about the case. The primary issue that we've got on appeal to y'all is whether or not the trial court erred in allowing Miss Liebetreu, after already having abducted the party's young children once, to exercise unsupervised visitation with the children outside the United States in their home country of Germany. We contend that the trial court abused its discretion in doing so. This court understands, I think, that the trial court has discretion in many ways, but it's not unlimited in parenting cases. The court regularly finds abuse of discretion in various aspects of parenting. We believe that where children have been abducted by a parent, the review ought to be particularly acute. And it should be done in strict accordance with TCA 36-6-608, which is the Uniform Act on this issue.
Let me ask you, I have a question. That was one aspect of this I was trying to understand. I know the judge put certain criteria in place, including a $50,000 bond, and acquired the child's German passport to be surrendered. Does the child have a U.S. passport?
Yes, Your Honor.
Okay. Is that the purpose of, in other words, the German couldn't just discard the U.S. passport and use the German passport? That was the idea. I was trying to clarify that.
Yeah, Your Honor, I think that the concern was that if there was she couldn't discard the U.S. passport and still have the German passport. That's right.
Okay. All right. So go ahead.
Ms. Liebetreu says that the trial court was correct in allowing that overseas time. She says that her conduct last summer showed that she was willing and able to return the children to my client's care. She also said the court acted within its discretion to permit that time overseas. And she claims that she has also done everything that the courts have required of her. And that too would support the trial court's decision. And we wholeheartedly disagree, Your Honor. This is not a Hague case, but the Hague has played a major role in the litigation. And it's worthwhile, I think, for this court to understand or hear from the preamble to the Hague Convention that was established in 1980. And that preamble states in its very first section that the participating states to the convention, desiring to protect children internationally from the harmful effects of their wrongful removal or retention, have resolved to conclude a convention to this effect. That's from the international community, of which a number of states, including Germany and the US, are now parties to. Equally important, I think, is that in 2010, our legislature put into place the Uniform Child Abduction Prevention Act, passed into law, as I said, in 2010. Under that statute, the trial court has an obligation to consider, and it did consider, when deciding whether to impose abduction prevention measures, as in this case, that the court has to determine first whether or not there's a credible risk of abduction of a child prior to imposing those measures. Well, the court found there was a risk, imposed some measures, but we don't think they went far enough. And if you look at the factors in that statute, one is whether or not a parent has attempted to or has abducted or attempted to abduct the children. And the answer in this case is an indisputable yes. In this case, we have a case where a parent actually abducted the children in the past. Another set of questions is whether or not the parent lacks strong ties, either financial or emotional or cultural, to this state or the United States. And the answer to that is also true. The mother lacks those ties. Another question is whether she has strong ties to another state or country. And the answer to that is also an indisputable yes. She has strong ties to the U.S. And you also asked whether or not a parent has engaged in any other conduct that the court could consider relevant to the risk of abduction. I don't want to mince words. Miss Liebetreu not only displayed prior conduct that showed she posed a threat to abduction, she actually abducted those children and kept those children in Germany for a period of 7 months in the year prior to the divorce in this case. And so this is not a case asking whether or not there is merely a credible risk of child abduction. This is a case where the child actually children were actually abducted. We have cited to you cases from Georgia and Alaska where actual abduction resulted in supervised visitation of the children in the future. We've also cited cases from Tennessee and Indiana and Alabama, all of which found that the mere threat of removing children to a different country or state made the person a risk for abduction. The Tennessee case that actually preceded the 2010 statute was a case called Green, Greene, which we cited in our brief and talked about it. And in that case, the mother alleged that the father had made some statements suggesting that he intended to abduct the children in Canada. And the court's reaction was to put in a substantial bond and make the visitation be supervised and in this area and not in Canada. So the timeline in this matter is important. The mother brought the children to Germany in May of 2019 with the understanding that the children would return to Tennessee after the father took some courses in Arizona. The father flew to Germany to bring the children home, and the mother said, they're not going home. And in fact, she went to the process of getting a restraining order in Germany to prevent the return of the children to the United States. Our client brought action under The Hague. The mother made a number of allegations which have been found to be false concerning the father. She alleged the father was a spy. She alleged that he was a drunk. She alleged that he had been abusive towards her. And those were made with an intent to keep those children in Germany. I think the Hague case disregarded them, and the case at the trial court in Tennessee did the same. The trial court in Germany found that the mother had unlawfully abducted those children and retained the children in Germany and ordered the immediate return of those children back to the United States. The mother didn't abide by that. Instead, she brought an appeal to the appellate division in Germany and didn't obtain a stay, but appealed to the appellate division. That appellate court, in a period of real quick period, found the mother's appeal to be, quote, obviously unfounded, and ordered the immediate enforcement of the trial court's decision. The trial court's decision, in fact, said this is immediately effective. The appellate court's decision said this is immediately effective. And also, the appellate court's decision on page 59 of the exhibits stated that this is a non-appealable decision. Instead of abiding by that decision, the mother re-argued the case, filed to re-argue the case to the same appellate court. That court rejected that, took 3 weeks to do it, but rejected it, and again said it is obviously it's obvious that the children should be returned, and that should be returned immediately. At that point, the mother did return it, perhaps under the threat that a marshal would get involved if she did not. There was that order in that court. So the standard on appeal here is, did the court abuse its discretion? And we think that it did. We think that the trial court should have made this future visitation between the mother and the children to take place in the United States and perhaps even to take place in a supervised condition. These children were, I think, were 3 and 5 at the time of their abduction. They're just a little bit older now, and they may be 3 and 5 now. And I apologize, John, I can't tell you their exact age, but they are little children. They do not have the ability to contest an abduction on their own or deal with an abduction on their own. And I think that's important, and it's important in The Hague, and it's important in the cases, some of the cases that I've cited. The mother was also ordered to pay the father's attorney's fees and expenses and bring in his Hague action. The father testified he had about $70,000 in expenses and attorney's fees in the Hague case. The judge at trial ordered her to pay him, I think, about $23,000 of expenses and attorney's fees. Ordered her to pay that. She hadn't paid it. You know, the mother makes a big point of having abided by all court orders. Well, the one she hadn't paid, well, at least one of the ones she hadn't abided by, was to pay these fees for the father.
Is that in the record?
It is, Your Honor. It is, Your Honor. And she was also ordered originally to turn over the German passport. She had to be reminded by a second order to do so. And so those things were not done. It wasn't a question, and I'll go to a different thing. She's also failed, Your Honors, to express any real remorse for taking these children from the father for the period that she did and removing them to withholding them in Germany. She has emphasized she hadn't broken any laws, and she's right. She hasn't broken any laws in the sense of a criminal law, but she certainly, each court that has looked at this has found that she wrongfully abducted these children. And then in terms of the German order, she failed to comply with the first German order. She failed to comply with the second German order, and it was the third one that she finally complied with. The children, as I say, they're young, they're physically, mentally, and emotionally unable to resist an abduction. And we believe that the trial court in this case, should have made this visitation take place here in the U.S. and should have made it supervised if the court saw that to be necessary.
Thank you.
Time's up. Thank you, Honors.
All right. Let's hear from the appellate. The second, Mr. Greg Smith. I think you're muted, sir. You're muted.
Good afternoon, Your Honors. Greg Smith, Montgomery County Bar. The other Greg didn't mention that he refers to me as the real Greg. I refer to him as the rich Greg. He and I usually, when we see each other, we're both on speaking platforms at different times. And I use that to my advantage when I go first, and he uses it to his when he goes first. Your Honor, the case before this honorable court comes out of Montgomery County, Tennessee. The appeal comes out of Montgomery County, Tennessee. The focus of the appellant's argument is Germany, in a case out of Germany. The discretion that the trial court exercised in this case does come by statute, and it comes from 36-608D. What was overlooked in the earlier argument was that the points of what had to be done to clear this visitation was made at the request of appellant's attorney. Appellant's attorney asked for a bond. Appellant's attorney asked for education. Appellant's attorney, and it was a different attorney at trial, but appellant's attorney also asked that we take it one step at a time. And if she does this, then she can have her visitation. And even on the motion to alter or amend, appellant's attorney said it's excessively and absolutely correct what the judge did. Part of what the condition precedents was to pay $23,000 to cover expenses for this case, not the Hague case. Ms. Liebetreu paid it. Part of the conditions for this case was to put up $50,000. Miss Liebetreu did it. Your Honor, Judge Golden, you asked what's the difference between the U.S. passports and the German passports. The U.S. passports, since they are taken out from this country and primarily shown as the father is the custodian, she couldn't have used those passports to move to India. The German passports listed her as the primary. She gave those up. When did she give them up? Within 2 or 3 days of being told to, but to do that, she was on a plane getting to the U.S. to give them up.
So the U.S. passport has restrictions on it as to the children.
Yes, sir. For minors, U.S. passports have. Also, the Hague
Mr.
case.
Smith,
Yes, ma'am.
so Mr. Smith, you're saying that there was only one order from the court that required her to do that and that she complied? The court didn't have to issue a second order on that?
There was a second order, Your Honor, but that was because the appellant tried to do a stay. There actually was a series of 3 back-to-back hearings. June 3rd, the order went down saying motion to alter or amend is denied, and here's what has to be done. The items were done. June 4th, appellant asked for a hearing, first of all, ex parte for a restraining order. The trial court said, no, we're going to do this by hearing. Gave us about 12 hours notice that it was coming, set it for 1 p.m. the next day, had a second hearing, did the second order saying she's still got to do these. And then she was in the air that weekend. That would have been a Friday. She was in the air that weekend, landed on a Sunday. The motion to stay from this court request was done on Monday the 7th. At the point in time, we had already given the passports to the trial attorney. So what had happened was these were going back to back to back, but she was following instructions. And part of that was to not only put together the passports, but also to get a waiver of appeal, which we signed that Monday morning and filed it with the trial court, as appellant was going to the appellate court asking for a stay, knowing that we, as a condition precedent to be able to see these children, would waive any issues that we would have on this appeal. So keep in mind, respectfully, Your Honors, we're on about a 3 to 4 day time frame of trying to get stuff from Germany to Clarksville, Tennessee. And so several of the things that were coming on the plane with my client. But what happened was the $23,000 that was deposited at that point, the state action with this court went into effect. And before that money was cut to trial attorney, all of this was going on. And by the time the stay was lifted by this honorable court, where she got here and she had to stay a couple extra days, lost her flight for 3 people and other expenses, then the court at this stage said, take out whatever expenses she had, which was about $14,500 total out of the 23 that our clerk was holding, give the rest to trial attorney Mike Williamson, give the part that's supposed to go to her to me so I can get it back to her. And interestingly, one thing that was not noted, the disbursement of that money was done by agreed order. So the complaint of that money didn't go where it was supposed to, there was an agreed order as to how that was supposed to be dispersed. Now, in regards to,
Let me ask you a question about that.
Yes,
So this was the travel expenses when she returned, and were those ordered by this court?
partially this court sent it back to the trial court to address it. The trial court
But
said
it was for travel expenses, is that correct?
travel expenses and facilitation to make sure that the visit occurred. And of that amount, $4,500 was attorney's fees, because for about a 3-day period, I had to stop my practice to jump hoops to get here. But yes, it was remanded and the court made specific findings of fact. There's no transcripts on those hearings before this court, but made specific findings that that visit wouldn't have occurred but for the attorney's fees.
Well, that's the question I have. In other words, are you saying that this $14,540.20 dispersed pursuant to an agreed order that included what is now being raised as an issue, these attorney's fees?
Yes, sir. That's exactly what I'm saying. Hold on
And
a
that,
second.
but was there, because when I was reading the order, it specifically talked about travel expenses, and I was trying to understand how these attorney's fees were considered travel expenses.
If His Honor looks at volume 3, page 357, on the remand order at points 1.2 and 2.2, the court specifically at 2.2 found and did the same in the same order at 1.8 on findings of fact that but for the attorney's fees and attorney actions, the visitation would not have occurred because the stay before this honorable court would have been left in place.
Well, but was that pursuant to this court's order providing for reimbursement of travel expenses?
Yes, sir. That was part of it. The way this court's order read was that it was remanded back for payment of such expenses for entry of an appropriate judgment. It did say unavoidable travel expenses caused by the temporary stay and determination of appropriate source of payment. That is volume 3, page 332, Court of Appeals, order denying Trap 7 injunction. The other thing that is interesting on this case is that part of the argument that appellant's making is that on the Hague issue in Germany, she appealed it. She should be punished for appealing it. She asked for a petition to rehear that order. Well, within a day or two of the order coming down from Germany saying this appeal is complete, the children were back with the father on his way back to US. That's exactly what appellant did in this case, asking this court, after the trial court denied the stay, ask this court to put a stay on it. It's exactly what he did here. The issue that's before this honorable court, the real issue is abuse of discretion. Lee Medical from the Tennessee Supreme Court said, was there a factual basis for the decision? Yes, there was. There's factual findings of fact. There were a couple of hearings with no transcripts included. Were there issues identified and legal principles followed? Yes, the statute that the judge followed was the statute that appellant was arguing. Third, was the decision within the appropriate range? Yes, it was. The judge specifically went down the laundry list of, yes, I want a bond. Yes, I want training. And these were the things that on the motion for new trial, appellant's counsel was arguing these are totally appropriate. Now, their brief says that the judge acted, I think the word was irresponsible, for following the request appellant made.
How did that come before the trial court? Was it pursuant to a motion filed by the appellant requesting these things? How did the court's decision on what to require under the statute, how did that come before the court?
First of all, the original order talked about it. And then we had a motion to alter or amend one to address the amount of the bond, but also how are we supposed to pay this bond? Who holds the money?
Now, who raised the statute though, in terms of, who raised that in the trial?
Originally, at the trial court, originally it was petitioner that did. We acknowledged that is the standard if the court was going to go that route. We didn't challenge that that's the statute that's in effect, but it was appellant that was raising and making that argument.
And requesting that relief from the court?
Yes, sir.
And when you filed your motion for new trial, you were contesting that, and he said that, and the appellant argued that it was appropriate relief?
No, sir. Actually, we were asking for the bond to be reduced. On the responsive pleading to that motion to alter or amend, the appellant really focused on that statute. And then the arguments, which were three, none of the transcripts are here, but there were three arguments. And that was a lot of the focus of it, was how, if there was going to be relief given, how is it going to be given? So no, we acknowledge that's the right statute if the court was going to go that path, and we did then. The problem is appellant wouldn't take yes for an answer. The court agreed with them. The court did what they asked, and the court implemented it. It's just that Mr. Liebetreu didn't think that his ex-wife was going to be able to do it, and she did. And one of the things, instead of trying to predict the future, which is what appellant's brief does, I think it's a whole lot easier to predict the past. And the issue of saying is irresponsible, and their brief twice said the children will never be allowed back. That was filed in November of 2021. The visit to Germany was June through the beginning of August 2021. She had already done what they said she would never do. And if she wants a visit this coming summer, she's got to put another $50,000 bond up. The reason the bond was returned to her was because she completed what she promised she would do. Credibility goes to the trial court. The trial court, the record shows, acknowledged she raised her hand and swore, "I will bring him back."
Mr.
History
Smith,
says she did. Yes, ma'am.
let me ask you a question here and make sure I've got clear what you're saying.
Yes.
So
sir.
you're saying that at the trial court, that the appellant asked the trial judge to invoke the requirements of 36-608
Yes, ma'am.
and said, trial court, please set a bond. Trial court, please make her go to parent or the education classes regarding abduction. And then we're fine with any visitation.
Well, I don't know if they went as far as saying we're fine with any visitation, but yes, they were the ones arguing for that. And
Well, what type of visitation were they arguing for at that point then? I mean, if they were saying, judge, set a bond, judge, make her go to class, and then obviously they must have said something to the court about what type of visitation that they were asking for.
their initial lead-in up to trial was 0 days with mom. Then they did eventually come off of it a little bit and say she could do supervised visits in Montgomery County, Tennessee. And there was questions on both sides of, COVID was getting in the way of things. But yes, the idea of put up a bond was brought up, and you'll see it in the transcripts from the trial itself. That came from petitioner's side. We were actually asking for the children to be placed primarily with mom. I'll be happy to answer any other questions. I think I've got about 8 seconds.
Not hearing any yet. Thank you.
Thank you, Honors.
Here, Mr. Smith, you have 3 minutes on rebuttal.
Thank you, Your Honor. I want to clarify something that we've been discussing. We did say in our response to the mother's motion to reduce or strike the bond, the mother's motion to reduce or strike the bond, we did say that it is appropriate, completely appropriate, to put a bond in place because mother wanted to leave with these children without a bond. But I think it's important to understand that during the divorce trial, my client argued against mother being able to take these children back to Germany to be able to take them back to Germany. He argued that any visitation she might have should be here in the States. The trial court then, I think we were asking it to be local, to Tennessee. The trial court then made a decision in a divorce and made a decision that she could exercise time in Germany with the children. At that point, we were then saying, if she's going to be permitted to exercise time, we need to follow this statute with regard to how much time she would get. We never conceded that she ought to have time in Germany. We were just trying to protect against the possibility she would do what she had already done, which is to take the children to Germany and refuse to return them. So I think it's important to understand that's why, that's kind of what happened here. It's not that we came to court and said, oh, it's fine, she ought to be able to go to Germany, we just need to set a bond to do so. My client was trying to protect it at each time. Mr. Smith,
Let me ask you a question.
yeah,
Does the record reflect that this first year that this bond was in effect, that the children went to Germany and that they were returned and that the bond was released for that year? Is that in the record?
I believe it is, Your Honor. If it is not in the record, it is true, what you've just said. And I think that Mr. Smith filed a motion to supplement the record after the appeal was filed, and the court granted that supplementation of the record, and that should be in there. But that did occur. But we don't think that, and we're not saying what we're alleged to have said, which is if she ever goes abroad with the children, she'll never bring them back. But we're saying that she remains a credible risk for not doing so, and that the background says we need some more protections than what we've got in place. Mr. Smith did talk about the fact that we appealed this after they waived their rights to appeal from the decision. And the reason we insisted on them having to waive their rights is to appeal. We didn't want a situation where mom goes back to Germany and says, oh, by the way, that case in America is still under appeal, so we don't have a final order. So that's why we demanded and asked the court to require them to waive their rights to appeal before she took the children to Germany.
Which they did.
Which was what?
Which they did.
They did. They did. She took the children to Germany.
No, and they waived their right of appeal.
They waived their right of appeal. Yeah, that's right, Your Honor. That's right. And
thank you.
I think I'm out of time. I appreciate the
Yes,
time.
I just want to say to both of you that we appreciate the collegiality between both of you. That's very refreshing and not necessarily what we hear all the time, and it's very, very much appreciated. Thank you for your argument. This is a very interesting case, and we'll get you an opinion as soon as possible. Thank you very much.
Can I say one thing to you, Judge?
Sure.
The first time that Mr. Smith and I had an appeal together, or not appeal, a seminar together, he did this rich Greg Smith and the poor Greg Smith routine. But he took it a step further. He called my wife and got a picture of me on a hike up in the Smokies somewhere, and he showed it up on the screen, and he said, "This is the other Greg Smith standing on his pile of money." And so, I never lived that down. So we appreciate y'all listening, and Greg, it's good to see you.
Well, we enjoyed having you today. Thank you very much.
Bye-bye.
This
Take
honorable
care.
court stands adjourned.